Elliot Felig, he's former prosecutor for the Manhattan DA's office, joins me now. Elliot, Bankman-Fried did not get a plea deal, which I find interesting. They didn't want to plea this out. How do you see it playing out?
Right. So it's the exception and not the rule for prosecutors to not offer any kind of a plea. And there are three things I think we can infer from that. First, it means they believe they have a very strong case. It means they're extremely confident. They think they have an absolute, what we call a rock crusher of a case, that they're so confident going to trial, no need to offer a plea. The second thing you can infer is that they think he's a pretty bad guy. They think he just, even if he were willing to plead guilty, he shouldn't receive any kind of leniency. And the third thing I think we can infer is that the government still hasn't really figured out a way to wrap its hands around the crypto industry in a regulatory way. But this is an alternative method of sending a message to the industry that we are watching and we are going to come down hard if we see any kind of fraud or inappropriate behavior. Let's put it that way.
And I want to pick up on that last point, Elliot, because as Kelly reported, maybe the defense is going to use this, lack of regulation was partly to blame for all this. I find that a hard argument to prove because fraud is fraud, right? It
is. So they're going to use the lack of regulation to tie into a defense of relying on counsel. That's a very tricky defense, but it may be the only viable one he has because the evidence is so strong. I mean, everyone around him has already caved in, so they're going to have a lot of cooperators. They're going to have a mountain of documentary evidence. The advice of counsel defense, though, is still a challenge because it opens the door to those lawyers who gave the advice to testify. Those lawyers aren't going to roll over. They're not just going to say, OK, yeah, it's our fault. They're going to be well-spoken people, professional witnesses to some extent, and they're going to push back against that defense. So I understand why they're going to go with that. They may not have any other viable defense. Still think it's going to be a real uphill battle. And the jury won't even hear about the advice of counsel defense unless they produce some evidence. You can't just throw it out there. You have to have evidence that he really did rely in good faith on bad legal advice.
Fascinating to follow. But while we have you, Elliot, the next one for you. President Trump back in court today. The judge did place a gag order on Trump after he went after the judge's principal clerk on Truth Social. What do you make of all of this?
So I would call this barely a gag order. I mean, the typical gag order is much broader, and it's designed to prevent witnesses from being intimidated or designed to prevent jurors from getting information that might affect or prejudice how they see the case. If it were a broader gag order, it might face constitutional challenges, but one as narrow as this, I think the Trump team is just going to let it go.
Very good. We'll have to leave it right there. Fascinating as always, but thanks for making sense of it all, Elliot. We do appreciate it.
Thank you.
Elliot Felig, thank you.